apologies for being a little bit late. This is because there are only 2 Germans on this panel. We are going to talk this morning about the balancing issues between data protection and privacy on the one hand, and freedom of expression and information on the other hand. This is the PING panel. PING stands for Privacy in Germany, a law review that we established, a bilingual law review that we established in 2013. If you're curious to see it, we have brought a whole pile of issues, of copies, on the literature table in the main building. The balancing between data protection and privacy is, of course, the issue of Article 85 GDPR. So we are going to be very focused on Article 85 this morning. And first of all, I would like to have a little talk with Horst on the left side. Horst Heberlein, who is an expert on data privacy in all aspects, if I may say so. You're from the Commission. You're at the DG Justice and Consumers, and there specifically your focus is on data protection. And of course, I am very, very curious to hear from you, Horst, what is your view of what is actually new when it comes to Article 85? The balancing issue is, of course, not new because we had Article 9 of the directive before that dealt with this. What from your point of view, what is new about Article 85?
Thank you very much. Yes, I think there are more new elements in this new Article 85 than one see on the first glance. Of course, the balancing requirement is still there, but it's now a regulation, not anymore directive. This means member states are obliged to reconcile the fundamental rights, these fundamental rights, but they are already obliged in the manner they do it, not in the directive where it leaves it open. They have to do it by law, so by legislative measures. And it's not only for special purposes. We have now, on top of this derogation and exceptions obligation, which was in Article 9 of the directive, now in Article 85, paragraph 1, which is a new provision, the obligation to have a broad balancing between freedom of expression and information and data protection. So it's not only for these special purposes, which are explicitly mentioned, but a general clause. And then we have the obligation to reconcile the right to the protection of personal data not only with freedom of expression, but also with freedom of information. This might give it a completely new dimension, also for interpretation of the rights and obligations of member states. And this exemption derogation must be provided by legislative measures, also extended to academic purposes on top of the special purposes which were in the directive. And this legislative measures must be in view of the balancing. So it could not be a global exemption of specific provisions, but it must be really balanced. This has not been changed. The balance requirement is there, but in a much broader environment. And of course, the guarantee of judicial remedy, compensation, liability, they must be kept as it was already in Article 9 of the directive.
So what would you say are the main challenges for member states' legislation under Article 85, do they have to legislate, or can they rely on what they already have?
It's an obligation to legislate. But that's other is a question, can they rely on what they already have? Of course, they have to review their current legislation to adapt it if necessary, and to adopt new legislation where necessary. It's an obligation, so it's not in the discretion of member states, but it's in the discretion of member states in what law they do it. They are not obliged to do it in the data protection law. They could do it in media laws and other laws. So recital 153 says legislative measures. It does not say by one specific legislative measure. So it's at the discretion in what law they do. And some member states have a broad range of media laws or broadcasting laws and so on, but they have to find a balance there. And as I said, they have to look, it's also in a recital 153, that it's for certain provisions. They have to see what provisions have to be exempted. We have a list of most of the chapters of the GDPR where they could do exemptions, but this means they could not globally say this chapter do not apply. They have to look what provisions are necessary. And I think the biggest challenge for member states is to ensure the balancing on a case-by-case basis. Either they give guidance already in the law, or at least they provide a requirement to do the balancing. It could not be globally said, this provision do not apply for journalistic purposes and for other purposes, but it must be looked on the individual case, taking into account the case law of the Court of Justice in Luxembourg and also of the Strasbourg Court.
David, if I may turn to you on my left. You're University Senior Lecturer in Law and Open Society in Cambridge. And I know that you have been, that you have had a particular interest in what is the topic today, because you have been working on right to be forgotten for a long time, and on the whole balancing issues that we're talking about today. Curious question. What was the sort of first? What was the reason that you were so interested in this specific subject?
Oh, I didn't know you were going to ask me that, but I'm happy to answer. Well, I can give you two answers, to be honest. On the one hand, I think if you go back sort of 10 or 15 years ago, then there was a big debate, at least in my, in the UK where I'm from, on privacy, mainly looking at the European Convention and freedom of expression, particularly in the media. And there was a lot of material produced both in popular press but also in academic journals. And it just missed off the fact that we have codified and quite strict and very broad laws on personal information, on personal data, which heavily regulate this area. And yet people just seem to find it just too technical and too difficult, and therefore we'll just ignore that bit. Well, to me, that was a bit like saying, well, I'm going to study intellectual property, but it's just too technical to look at the Copyright Patents and Designs Act. So I just don't look at that. I just do it generally. Well, that's ridiculous. That was one factor. The second factor, I have to say, was being practically involved in academic work, actually, and being confronted with, complete confusion and a whole range of different provisions which allegedly applied sensitive data bans, transparency requirements, and then thinking, hang on a minute, but this isn't what's going on in journalism, this isn't what's going on in the media, and we can't necessarily do our work as academics based on these kind of provisions, then why is no one talking about it? So it's really those two factors which came together and made me think, I've got to say and look and research into this a bit more.
You are interested in your sort of collecting information from all EU member states, as I'm aware.
Oh yes, and also the EFTA affiliates, let's call them that, Liechtenstein, Iceland and Norway.
Okay, wow. So you're the ideal person to ask, do you know how most states in the EU have reacted to Article 85? Have they enacted new laws, or what have they done if you look at the big picture?
Yeah, I mean, this is an ongoing project which I'm doing along with some research assistants to look at this. And so this is slightly provisional in everything I say. I mean, most countries have adopted law. Well over a majority. I mean, something, you know, if I had to pluck a figure out, I'd say around about 80% at least are now with a law, and most do address in their law the balance with journalistic, literary, artistic, academic purposes, the special purposes. I think that that's Article 85.2, which has the reporting requirement to the Commission in Article 85.3 and a clear legislative basis for derogations. I have to say Article 85.1, which just talks broadly of reconciling freedom of expression with no explicit ability to derogate, no powers to derogate, no steer, I find much more confusing, and it's not clear whether it's telling member states to use the other provisions in the direct regulation, like Article 23, general restrictions, or it's its own legislative basis to do something, in which case why isn't it subject to reporting? Why doesn't it give the legal basis? Anyway, most countries have ignored that bit, actually, though a few haven't. Some countries have implemented GDPR but not addressed Article 85 at all, Croatia, Spain, and I have to say I don't find it convincing if they don't address the relationship between their media laws and data protection, if they just leave it for someone to work out. On the one hand, there's a sensitive personal data ban. On the other hand, we have a Media Act. That isn't satisfactory. You need to explain in your secondary legislation what you intend to be the relationship, and some countries haven't done that. Some countries have been very late, but have just about now got round to implementing something. So Finland, I think, has just passed some law. I understand Bulgaria has only a couple of weeks ago, and some remain delayed. So we have no law at all, as I understand it, in Greece, Poland, and the Czech Republic, and in Liechtenstein in the EEA. So they could be other countries as well. So it's a bit of a mixed bag. I think you are going to ask me about the substance as well. There's been a lot of continuity from the past, but that's not usually because simply the old law has been plucked out and is being reused. It's because the basic tests and the basic approach show a lot of continuity. And this still results in vast disparities. So even though Horst talks about balancing, and it does seem that the article requires balancing, we still have countries like Sweden and Norway, and to some extent in the press sector, Germany in its actual law, which simply exempts the press from data protection substantively. There's nothing at all. And equally, as I've said, we have countries like Spain, which in principle aren't setting out any clear derogation. And other countries like the UK with a fairly liberal approach, Luxembourg actually with a fairly strict approach. So anyway, I can talk a bit more about how the substance is going, but there's a lot of continuity.
Horst, we were talking with Horst about how much Article 85 We were talking with Horst about the question of how much Article 85 changes the balance as compared to Article 9 of the directive. What is your view? To what extent does Article 85 actually make a difference?
Well, I mean, I've already talked about the potentially important steer to reconcile freedom of expression and data protection outside special expression in Article 85.1, but the confusing nature of that because of the lack of an explicit right to derogate, apart from using other clauses like there's a special sensitive data clause which allows a derogation in the substantive public interest. There's Article 23, which is general restrictions, but that's an important development, but it's very confusing. The second important development is the inclusion of academic expression, which I have played a part in, I think, bringing about in terms of academics being protected when they speak and they produce things for the general public. I have to say, though, there is still a very confusing relationship between those provisions and the much stricter provisions on scientific and historical research, and I see little evidence that universities and other research organisations understand or even national legislatures, the fact that freedom of expression is, of course, is a fundamental right ultimately prior to the detailed provisions which conflict with it, including in the research area. You would have a similar issue with public interest archiving and newspaper archives, apart from the fact the press wouldn't dream of interpreting it that way. And Article 153 does mention press archives explicitly, but member states need to address that relationship, but that's an important change. The Commission notification duty in Article 85.3 may be important because, Horst is here and it seems the Commission is taking an interest in trying to look at this area, try and bring some more consistency and close thinking to this area. And if that continues, that's very important. Ultimately, in terms of where the balance lies, I get the impression, of course, you could say, well, it's a regulation, therefore that changes matters. It's going to be up to the Court of Justice. And we have a number of cases which are coming. We have the Buvid's case, which is about the individuals and filming and journalistic purposes and how you define journalistic purposes, already subject to an Advocate General opinion from Advocate General Sharpston. We also have the Stunt case from my country, which is looking at prohibitions on getting injunctive relief in data protection in national law and whether that's compatible with the EU Charter and with EU law. I think the Court of Justice could play a significant role going forward, but in a way it's up to it to decide whether it's going to, rather than trying to go through every nook and cranny of the regulation.
Is there any chance that the Court of Justice will protect freedom of expression, or will they not mainly see their themselves as protectors of data privacy?
Well, if you look at going into the broader area of Article 85.1 now, if you look at the Advocate General's opinion on Google's processing of sensitive personal data, and to a certain extent the decision on territorial scope, you do see the Advocate General trying to strike a balance, to be fair, saying that there is the sensitive personal data ban, but you can kind of parasitically, indirectly apply sort of on the journalistic exemption if it's journalistic material at root or other special expressive material at root, and then there's a kind of a strict balancing test. That is trying to pass out the two values. I think where there's a reluctance in Europe and from the Court of Justice is to stay full squarely that actually having provisions on the books which say that it is prohibited to process political opinion, religious belief, philosophical opinion, criminality is actually not compatible with freedom of expression. And in not providing clear legislation to enable freedom of expression, member states are failing in their human rights obligations. We don't see that kind of clear language. Whereas we would do, say, maybe in a copyright case, where in fact member states failed to provide appropriate derogations. So there does seem to be a little bit of a double standard in not wanting to say, actually, like in copyright, the Europe has harmonized the non-derogating aspects of the law, the sensitive personal data ban, but it's up to member states compatibly with human rights, including freedom of expression, to enable the derogations which are necessary for these rights. And when they fail to do so, they should actually be called out on that. And that seems to be absent in this space.
When the logic for not striking the balance in the GDPR was that it was always said that there was no legislation for the EU on media law. So that may be the sort of root of why the ECJ may be reluctant to go very far as the protection of freedom of expression is concerned.
It may be a factor, although clearly in having a basis to protect personal data, and that's actually in Article 16 of the Treaty on the Functioning of the European Union, as well as in the EU Charter, Europe is necessarily getting involved in how to balance that with media, with journalism, and every other activity. So yes, it doesn't have a totalizing competence to regulate the media, of course not, but it does in certain areas like competition law, and now also in many respects subject to a margin of appreciation, if you like, or whatever the cognate here is. But of course it has some role in data protection in the media. But it's more that there is a general principle in EU law that in implementing legislation, you have EU legislation, you have a responsibility to do so in a way that's compatible with fundamental rights. And when you're implementing a bedrock principle which says that there is a prohibition on processing some of the most socially interesting, publicly interesting data, that is a tough job, and it needs to be done properly, and it needs to be taken seriously. And I'm not sure that the general debate, to be fair also, the lack of compliance with the law, the lack of respect for the law, is leading to that careful analysis that is necessary.
Let me turn to you, Olivia, sitting between Anna and Bojana. You have a microphone? Good, great. Olivia, you're a professor in Paris at the Paris-Dauphine Universite. Yes. Was that, how was my French?
Yes, that's correct.
Okay, good. And your focus is on...
Working, the mic, please. I think the microphone is not working.
Where does France come from? What has historically been the approach to the balance between privacy and the freedom of expression been like in France?
Okay, thank you for this question. I would like to underline that we should take France as an example of a state with an ancient and constantly concerned about the balance between privacy, data protection, and freedom of expression. Derogation from freedom of expression purposes for professional media, in particular written press, institution, and broadcast media, have been existed since 1978. And in 1978, it was only mentioned that provision on cross-border data transfer, prohibition of processing of sensitive personal data, personal data relating to criminal conviction and offenses should not apply to this professional media if it compromises the rights of freedom of expression. So the necessity of this balance between data protection with freedom of expression was included in the title itself of the law of 1978, because it is information technology, data files, and civil liberties. And I think that freedom of expression can be seen as one of the civil liberties. Then the original derogation was amended in 2008 for the transposition of the Data Protection Directive, and we had this artistic and derogation and literary expression purposes derogation. But still then, France maintains the derogation only for the journalists per profession. And the French implementation of Article 85 of GDPR illustrates the continuity with this restrictive approach of the focus on the professional media.
So what is the French approach when it now comes to implementing Article 85?
As we already mentioned, there are two obligations for the member states in Article 85. As Horst said, the obligation is to implement the derogation in national law, so we did that, but also to notify to the Commission what are the measures that the member states have taken. So in July, France notified two provisions regarding Article 85. One is interesting because, as you know, with the harmonization of the DPA power, we have a strong DPA power for investigation, and French include a special derogation in order to protect the journalistic sources in case of a visit of the agent of the CNIL in the premise of the controller. The second one is, I should say, a copycat of Article 85, GDPR. So I agree totally with David. We are in the continuity for French. I don't see huge changes. And the only wording change is the need to evaluate the necessity of the derogation to respect to the freedom of expression. It means that we do not have organical, should I say, exemption, but really we need to assess if we have the processing for purpose of journalistic expression, I mean in the French way, very strict, defined only for professional, we need to examine in each case if it is if the derogation is necessary. So as you see, for me, in the implementation, France had a very strong idea of what they can do because they think that they can be stricter than the wording of Article 85 because on the scope of the derogation, as I said. And for me, it does not include, for instance, blogger processing who are not always professional by profession. And this approach, I wonder, for me, this approach is not really conform with the case law of the ACG and in particular Stat and Media, and we have seen that the Cocotte, the General Advocate Cocotte, in his opinion, in Budis also recalled to this case. So for me, what I can say for France, it is only on the wording of the text, the concept of journalistic purposes is not interpreted in a broad manner. And I think that for me it echoes, I'm sorry, I will be very French at the moment, but for me this ancient reluctance echoes to the current debate in France about the lack of legitimacy on the traditional media. And it also rides in the current, I don't know if you are aware of this yellow jacket movement, where people more globally think that they need to have their own way to inform the people about their own movement because they are against the way the traditional media inform people about what they are doing. And there are also this debate about the emergence of a right to information to whistleblower. And I think that is not conform with this restrictive approach of French. As far as the derogation, can I follow? Yeah. As far as the derogation that we can apply when you can use this derogation, I should say that there is no fundamental changes, but that in the French law they put really which are the rights that you can not apply to the purposes for the processing of for the processing for purposes of journalistic. I would underline that there are also references of the right to reply and that we need to, the journalists need to be conformed with other civil law and so on. What I found also interesting, and it will be my last point about the implementation of Article 85 in France, is that there is also a mention a provision, I don't know if you are aware about that, about a French provision on the law applicable in cross-border cases in the exercise of the marginal margin of maneuver. It is to say, as you know, in the GDPR we have these opening clauses, and the French intend to say that when we are in these opening clauses cases, when we have a conflict of law, we have to, French put a rule about the law applicable. And they say that if we have this potential horizontal conflicts between national laws, we should apply this rule. And it provides that for French law, it's applicable to processing of journalistic purposes and for purposes of academic and artistic and literary expression when the controller is established in France. So I think it is also a way to have some guarantee for the professional media. For me, it raises two questions. First question, does France have the right to do that? Because for me, maybe it can conflict with other provision from other member states saying that it is a residence criterion and not the establishment criterion, for instance, that can be used in conflict of law. And it is not part of the provision that France notify in order to derogate to Article 85 of the GDPR.
May I just pick up you mentioned the Yellow Vests movement.
Yes.
And you mentioned in that connection the sort of the issue of what is actually a journalist, and sort of professional journalists being rather skeptical if everybody should be recognized as a journalist. And legislation in Europe struggling with how far the laws enacting Article 85 go when it comes to bloggers and non-professional journalists in the sort of traditional sense. I know this issue very well, being German, because we have so far laws enacting Article 85 for professional journalists. We have a very sort of patchwork picture on non-professional journalists, and this is an ongoing discussion in Germany, because this would require further federal legislation. And Paul, this is the issue that I want to talk about with you. We have something in common, Paul. My home university is the Freie Universität Berlin, and your university is the Freie Universität Brüssel. So you haven't had quite as far away to come here as myself. You're working there at the Law, Science, Technology and Society Department, and as I said, I want to discuss with you how is your view on national legislation all over Europe and the concept of what is actually a journalist and what actually falls under Article 85 and what does not.
Thank you. Hello, everybody. First of all, I should say I definitely will not be able to give an opinion on the national legislation all over Europe. That's far beyond my abilities. What I do know is that there is, as you say, a patchwork, and you see a sort of spectrum in what is recognized. If I take Belgium as an example, the concept of a professional journalist doesn't seem to be technically that important. The legislation refers to journalistic ends or purposes. So in theory, anybody can be a journalist in this context. If one, however, looks at states like Belgium that have this kind of construct, you see often a requirement, however, to act in compliance with ethical codes of practice. The UK has this also. There is in Belgium there is a reference to ethical codes, and what that means in practice is either a French-speaking ethical code for journalists or a Dutch-speaking ethical code. In the UK, there is reference in the legislation to a BBC code of practice, to Ofcom, which is a regulatory body, and a third one which escapes me. So in theory, in Belgium, for example, a person can be exempt if they are following the code of practice, if they are complying with the code of practice. What is important to bear in mind is, though, that compliance with the code of practice is not that simple for the individual. Because if you look at the Belgian code of practice, the Dutch-speaking Belgian code of practice, for example, a lot of it talks about the relationship with the editorial body of a journalistic organization. There is discussion about how data should be, how people should, keep information. And the BBC one, the BBC is an enormous organization. And the BBC, the whole code of practice is from the context of a big organization and your role within that organization and your role with others. So there is a lot of assumption that that from the codes of practice that this is about professional people, and the ability of individuals to comply with this if they are not professional is not impossible, but it's something that will take time and dedication and thought. So there is a de facto difficulty for the individuals. That being said, however, there are cases. There is a case here where an individual won, where he compiled a website of the 10 richest Belgians, and there was a case about this, and he was considered to be acting for journalistic purposes.
To what extent does public interest come in as a requirement for legislation based on Article 85 from your point of view?
Again, a varied picture. So I'm not going to say I'm giving you a total picture. From what I see, there is again a spectrum. Some states have a recognition of public interest in their legislation. Some have a sort of a modified form of what we think of the traditional public interest concept. In the UK, for example, I think the legislation refers to a reasonable belief that public interest exists. And I find that a very strange concept, because it's almost reasonable in the UK context refers to a belief that can be objectively justified, but the concept is very complex itself. A belief in something that's objectively definable. In Belgian law doesn't refer to public interest per se, but again it refers to these ethical codes that do speak of public interest often. So, in an indirect way, some states will require the public interest concept to be met in this indirect way, and other states, in Ireland, the concept of, we were talking about this, David, just before. As I understand it, the traditional concept of public interest doesn't exist. Rather, you have this, as you said, test of necessity to...
Or incompatibility. Incompatibility of the purpose with data protection.
Yes, so this isn't exactly a public interest test as I classically understand it. Rather, it's slightly weaker, I think, but perhaps the other panelists will disagree with me. So yes, there is a varied situation.
Just also on the public interest aspect, as every German law student, when learning freedom of expression and opinion, learns that demanding a public interest is already an infringement on the freedom of expression. And as I think Horst or one of you has mentioned, there's also the aspect of freedom of information. And how does freedom of information how can you protect freedom of information on the one side if you have public interest requirements on expression or distinctions between professional journalism and bloggers on the other hand, because from a freedom of information aspect, from the point of view of the person that is looking for information, why should it make a difference whether those are journalists, whether those are bloggers, whether there's a public interest behind the organization whose website is concerned, etc. What is your view on that?
Yes, it's an interesting question, because the public interest requirement represents, don't know, something akin to an objective valuation of the worth of the information to society, whereas traditionally when we speak about individual expression by itself is considered to be an important thing for society, and the content is not always as important. I mean, traditionally, the media, the journalists had access to means of dissemination that the individual did not. So the risk in terms of harms to individual rights, privacy, etc., was arguably greater for journalists than it was for private expression. Now, obviously, this is changing with social media. The amateur individual can be can reach almost as many people as a journalist through social media. So yes, this situation is strange now, and I think especially in France, if we look at the Gilets jaunes, there's a lot of the media reach of some of these so-called individuals is enormous, and so to ask why would they not be applicable to the same standards as a journalist is a difficult question to answer. Yeah.
May I turn to our chair, sitting on the right? You have to work as well, yes. Anna, I'm very happy you are here. Anna Buchta, head of the unit Policy and Consultation at the EDPS. What does the head of the unit Policy and Consultation do at the EDPS?
Okay. Hello, everyone. Thank you very much. That's not exactly the question I expected to be asked.
But I'm sure you have an answer.
Here. So basically, one of the tasks of the EDPS as the EU level independent data protection authority, in addition to supervising how EU bodies and institutions process personal data. So one of our tasks is also to advise the Commission, the Council and the Parliament on legislative proposals and on other initiatives that may have a data protection component. So this is what my team does. We issue comments, opinions, and we engage otherwise with the EU legislator on any file that has data protection implications. And thank you very much for having me on this panel, formally as chair, but as you understand, I will have to work as well.
Let's talk about possible differences between privacy and data protection when we talk about Article 85, the sort of traditional balancing act that we all know and have known for a long time, is the balancing between privacy and freedom of expression. Now we are all told that as there are two different articles in the Fundamental Rights Charter, Article 7 privacy and Article 8 data protection, that although the ECG always says Article 7, Article 8 and doesn't really distinguish all that much between the two, that in spite of that, data protection needs to be distinguished from privacy. What do you think, Anna, are the consequences for the balancing act that Article 85 deals with?
Well, thank you for this question, and in fact I wanted to talk about this in a, let's say, in a more pedagogical awareness-raising effort, but a lot of that has either already been mentioned earlier by David, or to me it was very much implicit in what we've discussed so far, in the sense that in my experience, often when you try to speak about balancing between privacy, data protection, GDPR versus freedom of expression, people's first instinctive reaction seems to be, oh yeah, but we have Strasbourg Court jurisprudence and, von Hanover and Mosley and whatever, and if it's a public figure, no problem. So I think that it's important that here in the context of Article 85, we are simply in a context of a different exercise. So here, because GDPR is first and foremost concerned with the fundamental data, right to data protection, we do not go immediately into this, balancing on case-by-case basis, but indeed the task for the national legislator in this context is to ask themselves, how do you apply in practice freedom of expression and information on the one hand, and the right to data protection on the other hand? And of course, the specific right to data protection, as you know from Article 16 of the treaty, Article 8 of the Charter, first of all requires fair data processing on a clear legal basis, which would be consent or something else. In this specific context, probably something else, more likely than consent. Purpose specification, access correction, independent supervision, and et cetera, et cetera. So my point is simply, it's a more technical exercise. It's verifying which of those requirements, plus some others that are set out in the GDPR in greater detail, how, to what extent do they still apply, should they apply in the specific context of journalistic activities. So it is indeed quite a tall order, as they say, for national legislator to consider all those details. And indeed, I would agree with some of preceding speakers. I'm not sure to what extent it is fully understood at national level, you know, how to go about Article 85. Does that answer your question?
Of course. When exerting your right of or your freedom of expression today, it is next to impossible without processing data. So the argument between 2012 and 2015 has often been that if you leave the balancing to the member states, by necessity means that you have a very, very mixed bag of data protection rules all over Europe. What is your view on that? Is Article 85 helpful when the aim of GDPR is safeguarding the same level of protection all over Europe?
I think it's a complex picture and obviously a mixed bag, I would say. I would still argue that despite its obvious deficiencies in terms of ensuring a high level of harmonization, but I'll come to that in a minute, I still think that the fact that we have an article like 85 in the GDPR in itself provides added value. Because let's be honest, the legislator was not obliged to insert here anything. You know, we have other examples of potentially conflicting rights protected at constitutional level, like in this case. And then it boils down to application of the rules in a balanced way in case-by-case basis, usually sorted out by either competent authorities or the judges and the courts ultimately. So here I think that explicitly recognizing in the major data protection legal instrument that we have at EU level, that this fundamental right has to be balanced, reconciled, which means balanced, with the other fundamental rights, which are equally important in itself, is a very important message. Now, as to the harmonization, I think that I am slightly more skeptical than I guess David is to what extent the EU could really legislate and harmonize more when it comes to media and freedom of expression. But to the credit of the European Commission, you would remember probably that the initial proposal for the GDPR included the possibility for the Commission to issue what's called delegated acts, which are specifically meant, according to the treaty, to address situations where there is a need to ensure harmonized application of EU legislation across the member states. So the need for greater harmonization than possibly possible on the legal basis of Article 16 of the treaty was recognized, but it was the co-legislator who decided otherwise. Now, I'm not very surprised about that, because traditionally, I think we will all agree, this is an area which is indeed left for the member states to regulate in general. The broad discretion for member states in this context has already been recognized previously by the Court of Justice. So there is continuity there, but then again, indeed, there is a risk that a harmonization of the rules will suffer, yes.
Anna, your home country is Poland. My home city is Berlin, which is very, very close to Poland. We have a lot of links, connections to Poland. 30 years this year, the wall came down in Berlin. And I can very, very well remember, I grew up in the west of Germany, and studied in West Berlin, but went to East Berlin a lot. And my whole, the reason why I can get quite emotional about the protection of the freedom of expression is because by having friends in East Berlin, I learned I learned to value freedom of expression, because I learned what it was like if you had to expect police and Stasi coming after you because you have said a wrong word to somebody in the street. So I think, and as we all know, in some East European countries, no generalization here, there is still sort of rather fragile protection of freedom of expression is a fragile issue still in some Eastern European countries. There has been the recent Romanian rise issue. What would you think, or what is your view, Anna, on what lessons can be learned from the Romanian incident?
I'm not sure I should thank you for this question. I told you before, I was hoping I could get away without being asked about this case. Yes, but that's my reluctance is just linked to the fact that, as you probably understand, as an EU civil servant, my personal freedom of expression is somewhat more circumscribed than it's the case for academics. I have to be cautious, because I have to say I do not have all the details before me about what exactly happened in that case. We have a lot of second-hand, sometimes very emotional reactions, accusations, and it's not entirely clear to me what happened. So I don't want to pass any judgments here on the behavior of either side in that dispute. Nevertheless, what can be said that clearly that incident crystallized and raised some very important questions, which to me go way beyond Article 85 as such. So, who is a journalist, who qualifies for special treatment under data protection rules, protection of journalistic sources, and how the various member states' legal systems go about this, even in other contexts, including criminal investigations. To what extent it is obvious for everyone that these type of information requires specific protections? Is it necessary to spell out always in national data protection codes again that journalistic sources are protected? In any event, now I'm not sure that these letters have already been published, but you should know that the EDPB has considered the case, which was prompted by a number of letters from civil society and MEPs, members of the European Parliament. So they should be published very, very soon. And in those letters, the EDPB clearly states that the right to data protection, including the investigative powers of national data protection authorities have to be balanced against the protection of other rights which are equally important. In particular, the right to freedom of expression and information. And it states, it goes without saying, that the protection of journalistic sources is a cornerstone of the freedom of the press. So I think this is quite, maybe stating the obvious, hopefully for many, but it looks like a strong statement from the EDPB. And just to, that would be it.
Anna, thank you. The stronger data protection becomes, the more likely it is it will be misused in order to stifle. Yes, thank you. Civil liberties, because this is in the nature of balancing. And so I agree that there is a wider issue. This is not just freedom of expression, because there are many, many balancing acts that data protection has to do. The stronger data protection becomes, the more endangered other civil liberties will become. So this is where I have to bring you in, Bojana, at last.
I'm worried now.
Bojana, I'm very, very happy that you are here. No, you're not worried. You're so fearless. I don't think I would never think I'm able to get you worried about anything. Bojana, you're the president of CIPL, the Center of Information Policy Leadership. I think some people might have heard of you, or not to say everybody knows you. I'm very, very happy that you're here. And I'm very, very interested to hear from you on the sort of wider implications of Article 85 and the issues that we've been talking about now.
Thank you, Niko. And we always, Niko and I collaborate so much that he invites me to things I know nothing about to talk about. But in fact, I do have some views. As you know, I'm very opinionated. And I do have to say, I find this extraordinarily fascinating panel and really makes me think about things. And I'm glad you raised the wall in 30 years. I come from former Yugoslavia, from Belgrade. That's Serbia now, and kind of I sort of also understand the lack of freedom of expression. And in fact, in my country, some people who get expressed or used to get expressed ended up, in bad places. And today, I mean, this debate is so important because people who express themselves on the internet, get bullied and tweeted and misogyny. So I think it's kind of incredibly important topic, frankly, in this balancing of rights. And I'm glad you kind of made us think about this. So my angle today would be really very much, Niko, on what I'm seeing in the whole of GDPR. And David, to your point, I don't think it's only Article 85 where this whole balancing of different rights is expressed. And I think that organizations, and I come from private, I used to be privacy head of a global organization. I work with huge amounts of leading chief privacy officers in many global and European organizations. And I think all of us have to be much better to actually start balancing some of these rights despite and outside of Article 85. Now, what do I mean by that? First of all, the whole GDPR has a risk-based approach incorporated in it. So every time we are doing a project, initiative, a processing, a new technology, we actually have to consider risks and impact on rights and freedoms of individuals. That's not just data protection, right and freedom, I would say. I think it's more. I think it's other rights and freedoms, and I think freedom of expression, freedom of information become also something that we have to balance and think ourselves, is what I'm creating, the technology I'm deploying, going to have a negative impact on all of these freedoms and rights? And I think this is such a big ask. And in the moment, companies are very busy developing risk frameworks for privacy impact, but there are only few companies that I know, and I'm starting to work with them, who are developing a wider human rights impact assessments as and when they're developing tools and technologies. And I think that's something that we'll all have to do better. So that's the first point. Second point is legitimate interest processing. I mean, dare I say, that's a balancing act in itself where I have to decide whether the processing that I'm proposing is in my interest or interest of a third party that could be society or larger group versus the rights and freedoms of individuals. Again, not just data protection rights, but other rights as well. And I think in this balancing, there will be cases where we'll have to ask ourselves, you know, freedom of expression, information, the wider benefit for the public versus the right to data protection, just like you have, Niko, said. And again, you know, this is exactly one of the elements of accountability, this ability of organizations to be accountable for their data protection and processing. And that's what the legitimate interest enables companies to do. So again, you know, I know companies are trying really hard to document and do this, but this has to be done repeatedly. That has to be done in a way that it becomes part of institutional history and know-how, so that it's not just how Bojana says it, or how some chief privacy officer says it, but it's actually something we as a company keep repeatedly repeating and doing in the same way. And of course, the same is going to be the case in DPIAs. Now, I think it will be really interesting to see how data protection authorities also balance some of this stuff, because it's not, obviously, they're going to be considering some of these rights in response to complaints, in response to, you know, their own ex officio kind of investigations. And of course, it will be interesting to see how the courts are balancing. And dare I say, I think the court started to do that balance with Coster judgment, right, for the first time, where they talk about, I mean, the legitimate interest, Google having legitimate interest to process data for search, and then giving some instructions to Google as to how to balance itself the right to data protection with the right to freedom of expression. So that may be my second point. I wish Google was here because they could talk much better about this than me, but I've heard lots of these presentations, and it's really interesting to see sort of how they have done this. In the context of right to be forgotten and Coster decision and delisting, I think they have had, 800,000 requests, maybe that's even more, 3 million URLs, and about 44% resulted in delisting of these. And I think Google has come up with a very interesting methodology as to how they consider these two rights, or three rights, or multiplicity of rights, and of course public interest. As I know, they've got an army of people doing this every day as a matter of their jobs. And of course, there were some really interesting cases here where, you know, when they decide to delist and when they don't decide to delist. And some of these are being, of course, taken through national courts and have ended up in the European Court of Justice. And I am with David very much incredibly emboldened and encouraged by the Advocate General. Is it Spunja? I had never pronounced Spunja. Is Slovenian? Spuner. Is he Slovenian? Oh no, Polish. Apologies. Okay, Spuner. Thank you, Anna. That where he really tries very nicely to kind of balance this freedom of expression with data protection, and also, frankly, considering beyond European jurisdiction. And I find it's also, you know, very bold, because you know, we are not an island in this world. I mean, technology, data is so global, and you have seen in this Google versus CNIL case, you know, what are the limits to application of the right to be forgotten versus freedom of expression that exists as a constitutional right in some countries, like US, for example, or exists anyway in other countries. And I think Advocate General, incredibly sober, incredibly pragmatic approach, saying, well, actually, you know, our rights must have some territorial at some point they have to stop, because they start interfering with the other legal regimes. And if we start interfering with other legal regimes, then these other legal regimes can start interfering with us back. So I think this is incredibly pragmatic. I don't know where the court will end. Some people here are bigger experts than me, but I hope that gets upheld. My last point, you kind of also asked me kind of about Article 85. Of course, I understand the EU law, but it is a shame that this is going to be such a huge disparity between member states. And I think in this world of internet, and where everybody is communicating, everybody has got somehow right to say something and feel they've got right to say something, that this whole journalistic purpose or academic or literary purpose. Is it my literary purpose to just start, publishing things on a blog? Is going to be really challenged. And just like I was thinking about this, as you say, bloggers who actually paid for their blogs. I mean, they're running a company. This isn't a private use of data anymore. It's not, they are not actually exempt from GDPR anymore, nor are they exempt from anything else. But do they really understand this? So I think we're going to be, I really look forward. I wish, David, I can go back to your class and be a student and kind of really think about this, because this is incredibly interesting. But to your point, Olivia, you have raised this. Here is where Article 85 is going to find we're going to see some tension in the application among the data protection authorities, and that is because of the consistency procedure, right? Where you have got a lead DPA as per Article 56, they may be obliged. So lead DPA is the DPA of the main establishment of the controller, but it is possible that lead DPA may have to apply individual member states' requirements if there is a case that requires balancing with the freedom of expression. And there may very well be cases like this, because they could be complaint-led, they could be, delisting cases, they could be cross-border cases, and I think this is where I really don't know how. It's going to be really difficult for one DPA to frankly apply culture, background, constitutional knowledge, all of another member state law. But that's what it seems to me they will be required to do. And honestly, at this moment, I don't know whether we have a case, but I kind of see quite a problem in that. And this isn't just about delisting or these big sort of companies, Google, but even rights of individuals are somewhat limited by other rights like freedom of expression. So each controller may be faced by this decision whether I will curtail your right to erasure or curtail your right to restriction of processing based on other rights. And if I'm doing this across Europe, that becomes a cross-border case. And then one lead DPA may have to decide based on the law of another, and I just don't know how they're going to do that. So here's my stream of conscience.
Thank you. I would love to continue our conversation on the panel, but looking at the time we are running out, and there is a question. And can I have a mic again, because that seems to have got lost on the way. So, you have the floor mic. The lady in front here, please. Could you please try and be as short as possible?
Hello. That's going to be difficult because I come from Romania. And I've been very close to the RISE project case. So first off, I wanted to make a short comment about that and give a little bit of context that hasn't been as widely reported, I think. So the RISE project investigation that led to everything that we know today involves politicians, corrupt politicians. And I wasn't surprised to see the approach of the Romanian DPA basically asking them to reveal their sources and a lot of other things, because the request is actually quite long and it has 11 points in it. Simply because the head of the Romanian Data Protection Authority is politically appointed. And she has been in the same political party with the corrupt politicians and very close to them that are now being investigated. And it's not surprising that the approach of the DPA has been, okay, you need to stop doing this because we will come and push you. Now, on the other hand, what I have seen, because my entire practice has been overwhelmed with requests for help from journalists, is that a lot of people being investigated and being the subject of press articles, justifiably, have tried to use this data protection to their benefit and making lots and lots of requests to have their data deleted from news articles, online and offline, which is, again, ridiculous. We know that, but they don't. And they have been making a lot of pressure with this. So Turning also to a question now, because that was a comment. I'm sorry for taking that long. What can the Commission do after it receives the reports from each member state about how they have implemented Article 85.2? And why am I asking that? I have seen, at least in Romania, a very poor implementation of Article 85. What they've done and what we have to deal with is basically something like, in these three situations, which are the data was made public by the data subject, the subject matter relates to the public capacity of the person, or it relates to the public nature of the facts reported, GDPR doesn't apply at all, which is obviously a very strange approach to things, and it doesn't really do much. And what can then the Commission do? How will it deal with this very non-uniform approach and regulation? Because in my view, what states must do goes far beyond this, not only balancing the rights and showing entities that will have to do this balancing test further, how to do it, and instruct them. They actually need to be regulating much more than this. In Romania, we don't have a press law. There is no regulation of what a journalist is. There is no regulation of who can claim a journalistic purpose. There is no regulation on protection of sources. It's just a principle that everybody is applying. So I think the problem goes much further than 85.2. And my, hopefully, line of defense in this will be the Commission. But can it actually do something about it? And another question, if there's time, how do you see the interplay with the European Convention of Human Rights? We have vast case law already about freedom of expression there. Thank you.
Yeah. I think just referring to your comment on the Rice case, the independence of the DPAs and party politics there's a conflict that goes beyond Romania. I was recently asked by politicians from a non-EU former Soviet country how this was possible. How could a DPA be independent if the head of the DPA was a member of a political party? They just didn't understand how this was possible. This has to do with party structures, and this is the former Communist Party that is ruling, that is in government in your country, and this is there's a big conflict between party politics there and independence. So this is not just true for Romania. I think the question you asked about Article 85 is a question that you are the ideal person to answer.
Thank you very much. Yes, the Commission currently looks not only on the Romanian law, but on the law of all member states, assessing if it's compliant with the GDPR. So it's not only an issue of Article 85, but all requirements. And this is also, we're looking also on the independence of Data Protection Authority. And the important point is, how are they appointed? Are they appointed in a transparent manner? What does transparency mean? What requirements are there? And are they met? And I would not say the membership in a political party as such is a problem. We have, I would say, in Germany, also DPAs, which might be in a political party, or high court judges who are in a political party. But they have to act independently. That's the point. Not to take any instruction from anyone. And when they are appointed or selected, they must be a real personality who are not acting under pressure from outside. That's the point to that. So it's of course we look on the law, and also on the laws implementing freedom of expression. But when you the less law is codified, the more the case law is important. So under the Charter, it's the case law, and also of the Strasbourg Court is very important, which is also recognized by the Court of Justice in Luxembourg. So at the end, if such situations are, and even if the Commission takes action by infringement procedure, at the end it will be the court who will decide, and then we have, at the end, legal certainty. It takes some time, but there is a mechanism there to look on this. But I said, Commission is currently in the phase of looking on all member state law and having an overview, but we are not yet there. Thank you.
Thank you very much, Horst. And thank you, all panelists. Yeah, I've really enjoyed this panel, and I've really enjoyed our discussion. And there are so many questions that I would like to discuss now, but we're just running out of time. And I'm sure there's 1 or 2 or 3 of you who have questions. Just ask them directly, I would suggest. And thank you very much for holding on, and all have a great conference.